Good evening. Welcome to FDPPI's Jnanavartini series. Information Technology Act 2000. The primary law in India for matters related to cybercrime and e-commerce was created in the early days of India. In the past 23 years, the internet users have grown exponentially. The complexities and the type of intermediaries have grown manifold. So have the risks. The digital revolution has actually made the current regulations a little outdated. On 9th March this year, government has unveiled the draft of the new Digital India Act, proposed to replace the current ITA 2000 and expected to manage these complexities. Today, Mr. P.B. Viswanath is going to give us an overview of this Digital India Act. Mr. Viswanath heads CyberLex Solutions, a techno-legal firm. He has over 28 years of experience in handling cybercrime, cyber forensics, cyber security, data privacy, IT audit and compliance, IT infrastructure, and intellectual property. Thank you for agreeing to do this session. Over to you.
Thank you, Manju. Good evening, everybody. A warm welcome to you all. Well, even though there is my name that I'll be giving an overview, it is more or less, we'll have an interactive session. We will all discuss about this proposed Digital India Act. And the presentation I have today, it's already, projected. And this is from the Ministry of the Electronics and Information Technology itself. The reason being, see, other than this, there is nothing much on the public forum. The draft bill is not presented yet. It has not come out for the public consultations. However, the first interaction of, at least in my opinion, this is the first time where the ministry is coming out asking for public consultation, where even before the draft bill is out in the public domain. Generally, what happens is a draft bill will be presented. It will be open for public consultation, and after that, it will be taken to the cabinet and the parliament and so on and so forth. So, in my knowledge, this is the first time something has happened like this, and in my opinion, it's a positive move. So, the first interaction happened in Bangalore on 9th of March, and many from the industry did attend this. Basically, it talks about, the first slide, if you see, it talks about the IT Act 2000, which is in the present form, which is a present IT Act. And, it talks about the background, the limitations of this particular act. You can stop me anytime if you have any questions. We can discuss, it's a free flow discussion. Okay. So when the IT Act was initially, when IT Act 2000 was formed, the internet per se was in the very early stages of this digital explosion, what we can say today. And for this particular act, there was a major amendment in 2008. While all this happened before the e-commerce boom, the dot-com bust, even the privacy became a fundamental right recently, and now there is a demonetization. There is a lot of digital push from the government, and the new technologies have emerged. Particularly the social media, what we see today. Social media is everywhere and in different forms. Okay? And the mobility, particularly without mobiles, nothing is happening. Almost everything happens today, including the crime as well as the victims. It mostly happens through mobiles. And automation, what we see, and the cloud. So what I can say is, before all this, actually, this IT Act 2000, it came into existence. And this particular act was probably did not foresee, or not only this act for that matter, no other act can foresee the technological revolution. And today we have a limitation in not only addressing these technological advancements, at the same time, even in the legal framework where we can handle the cyber crimes effectively, where we can bring the offenders to books. That is not happening the way it should happen. You know, in addition to that, drones, the artificial intelligence, machine learning, there are a lot of things happening. Well, in my opinion, yes, the new act, the new proposed act is good. Even that will not be able to handle everything. Probably in the next 5 years, even that will also have, the challenges and it needs amendments as and when required. So that is my opinion as well. And the law enforcement as well, also what we see today, see, law and order is a state subject. Okay, and but the cyber crime, if you see, it doesn't happen from within the state. It can happen from any state within India, or for any country for that matter across the world. So handling these cyber crimes is today, it has become a great challenge. Okay, and that is where we see a lot of gaps, and hopefully the new Digital India Act will address most of this. So any questions so far? Am I audible?
Yeah, you're audible.
Yes, you're audible, sir. Fine.
So if you see, this is the current regulatory landscape what we have today. When we have the Information Technology Act 2000 with the major amendment in 2008, that is what is in existence today. And only one of the sections like 43A talks about the privacy, and again it has the rules on that. The use of electronic records and signatures. If you see digital signatures, there was an amendment for the Indian Evidence Act as well in terms of 65B. And for blocking certain websites or removing the content, there is a separate procedure for that. And recently there were the intermediate guidelines also were announced, where but we saw the legal battle between the government of India and Twitter. And in terms of the compliance officer and other things, what we saw. And we have the certified authorities rules. And we also have the CERT, which says that any breach has to be reported. But in my opinion, that is not strictly followed. And also the cyber appellate tribunal, where at least in my opinion, what I can say is, see, everything is in bits and pieces. And it is not really addressing its objectives. It is not meeting the objectives where we can bring all this cyber crimes or the privacy and the other issues. It's not able to handle comprehensively. So the government of India has rightfully, it has thought after these technological advancements, and also after the various judgments of the Supreme Court and the High Courts as well. And, it has thought that it will bring a new act, which is called the Digital India Act. In my opinion, it should have been called, the Information Technology Act 2023 itself. If you see any other act, for example, if it is a Companies Act, it was in 1956 earlier, then, New Company Act came in 2013. So the name of the act will generally not change. But however, in this case, it is proposed to have a new name. And still, since it is still under discussion, hopefully, in my opinion, the government will retain its old name. Its old name. That's what I wish. Any questions before we move to the next slide?
One question, maybe. Digital signature, Srinivasan here. Digital signature will be like a biometric, sir, or?
Currently, it is not.
Okay.
Okay. See, today, if you see, most of these government organizations also, they use digital signatures for their payrolls, as well as salary processing, everything. But, if you see, this, many of these officers, they hand over their key to their subordinates, and they do most of the stuff. Okay, so even though the intention of the government is good, but on the ground, somewhere, in my opinion, we are failing miserably.
Okay.
Shall I add?
Yes, sir. Yes.
Srinivasan, this digital signature is a very unique system.
Okay.
Where you take the document, whatever you want to sign, and create a hash value using a accredited hash algorithm. Today it is SHA-1. Okay. Then this hash value is encrypted with the private key of the person who is signing. This private key comes from a digital certificate which is issued by the certifying authority, which is a license certifying authority. And it uses the asymmetric crypto system where there is an encryption for which there is a public key and private key. And private key is always held confidential with the owner of the digital certificate, who is the signer. Public key is actually shared in the public. So anything which is encrypted with the private key can be decrypted with the public key, and anything which is encrypted with the public key can be decrypted with the private key. So that is the asymmetric crypto system. And the certificate, digital certificates provides this two keys to the person who registers himself with the certifying authority. So what we call as digital signature of a person of a document is the hash value of the document encrypted with the private key of the person. It is an electronic file which usually gets attached to the main document. And when the receiver gets the main document, he gets it along with the digital signature. And if he wants to verify who is the person who has signed it, he will look at this digital signature. Using the public key, he will actually decrypt it. And the moment he is able to decrypt with the public key of X, it is considered to have been originally encrypted with the private key of X. So that establishes the identity of the person who has applied his digital signature. Then looking at the hash value and himself calculating the hash value on the document he has received, he can also check that no change has been made in the document. This is the principle of digital signature. It has got nothing to do with the biometrics, and biometric can be used as a trigger. As of today, the trigger for invoking private key for encryption is basically the password. And normally the password or the private key is actually loaded onto an external cryptographic key, which is attached to the USB port. And that is something which a person can take out and keep it in his pocket. So he has the control over the use of the digital signature. That is digital signature. Don't confuse it with the biometrics. Okay. It is a software process of calculating the hash value and encrypting with the private key. So I think that is simple explanation. Just
thank you, sir.
To ensure
thank you, sir. Okay. So one last clarification. So it is not, as it is unique with the owner, right? It is not a personal data, no, by any chance, no.
No, it is private key is always considered both private key and public key. The combination is unique with the digital certificate. And out of that, there is a legal obligation for the person to ensure that private key is always kept confidential. And so that is how it has to work. But as Viswanath was telling, sometimes people don't understand the importance of that and then share their USB crypto key with somebody else, which is actually a punishable offense, 2 years imprisonment as of now. Now, government has also introduced a e-signature system, which is a real-time online application of digital signature, which is also possible using an Aadhaar-based system. So that is a one-time digital signature applied for a specific document, which can be done online. Okay, I think we should discuss this digital signature if it is necessary in a separate session, because there is a lot of confusion in the corporate circle about DocuSign and other things, which are not perfect examples of legally accepted digital signature. But because the discussion came here, and just to ensure that there is no misunderstanding, I just wanted to explain.
Thank you, sir.
Okay.
Thank you.
Yeah. Go ahead, Mr. Viswanath.
Sure, thanks, Navi. Any more questions before we move to the next slide? Okay, then the new Digital India Act or the proposed Digital India Act 2023, I mean, it gives the goals for 2026. I mean, this goal for 2026, what I understand is it is as per the PM's goal. Probably we will discuss in the slides ahead. And the need for global standards, the goals and proposed structure of this particular act, and the way forward. So, if you see the digital goals, Digital India goals of 2026, this is where it coincides. Where the India, the Honorable PM wants India to be $1 trillion digital economy by 2025-26 by self-sufficient means. And the other things like the innovation, entrepreneurship, how we India can play a significant where India can be a significant player in this technology space, and on all this. So that is where the government is trying to align this particular act, where the entrepreneurship, the business, the ease of doing business, and other things are taken care of. So, okay, see, when we come to these particular laws, particularly whether it can be the cyber law or it can be the the intellectual property laws, see, these, since they are not confined to one country. See, most of this, if you see, a cyber criminal can be sitting across the world, probably anywhere in some other country, and he can commit a crime in India. That is a possibility, and most of the times it happens that way. So here, just being a standalone or an isolated country, I mean, in any country for that matter, they cannot do anything to get hold of the person. And in the recently, if you are seeing this cryptocurrencies where India brought it under the Prevention of Money Laundering Act, this cyber terrorists particularly, they were using, one is the ransomware, where they used to lock the machines of the users, and to unlock, they were demanding ransom in cryptocurrencies. So one country cannot do anything. So there were multiple forums that those were discussed, the issues were discussed, in Davos and other places, and the countries who were signatory to they all came together and they wanted to ban this cryptocurrencies, and that is where most of these countries are acting to ban cryptocurrencies in their respective countries. So similarly, if you see the cyber laws, say we cannot have our own cyber laws, and we cannot try to achieve, which is impossible. So it is even the present IT Act, what you see, it is that the draft was given by the one of the branches of the UN, and that was enacted in all the signatory countries. I mean, that is how as I said, the Intellectual Property Act and all other acts are also where the common commerce and trade is involved. That is how it happens. Even now, the proposed cyber law in India, that is the Digital India Act 2023, also will have to align with the global standards. And that is where this particular slide talks about the alignment of the new Digital India Act with the global cyber security standards, or the global standard for cyber laws. Okay, and the objective, anyway, the objective of this is, again, the economy. Basically, if the countries will have to cooperate, and the economy is the key, the trade and commerce is the key, and that is where they come into picture. Any questions? So, what are the objectives of this global standard for global standard of cyber laws? There are about 7 objectives which have been listed. As I said, this particular slide deck is from the Ministry of information technology itself, electronics and because well, nobody has more information other than what is already given, what is already in the public forum. See, the first point what it mentions is open, safe, and trusted and accountable. So what is this, open internet? What it really means? I mean, I'm just throwing this question open to everybody. What this open internet means? Any participation? What is open internet?
Like API driven. All information is available to everyone so that they can access it using APIs.
Right. See, no, basically it is net neutrality. For example, see the ISPs today, the internet service providers today, they cannot decide, for example, I'll just give one example and probably we can, discuss if we have questions. See, today we have, that service, whatever we order, for example, the home delivery, we have Swiggy and Zomato today. One of the ISPs, they cannot, have any financial arrangement with one of those service providers. And when the customers order, Swiggy will be very fast and Zomato will be very slow for the customers. We cannot do that. Any questions?
No, you go ahead. I think somebody has not muted.
Okay, please mute. So net neutrality, the ISPs cannot decide that they give, one of those vendors will have a favorable access, the fast access, and their competitor will have slower access. That will be very, detrimental to the business prospectus of the competitor, right? In that case. So, this is just one example I gave. There are multiple examples on this. So net neutrality, that is extremely important. And the proposed act is, they want to address that. As of now, when US and other places, they had court cases on this. But, net neutrality was upheld. And most of the cases in the upcoming slides also, it is the foreign judgments only, which are being considered for this particular act. Safe. Again, what is safe? See, today, if you see a lot of, particularly for the women and children, a lot of, content which is available in the social media sites, particularly, all actually, I cannot name one or two, but almost all social media sites is full of pornography and the other, the other acts as well, where it is unlawful. So, the proposed act wants to address this. Well, it's a extremely good idea, or the good objective, or the good intent, I can say. But other than making it punishable and blocking a few sites, I do not know how government really wants to address this, because this is, the other countries also, they are not able to address this effectively.
Viswanath, Ramesh here, just quick question.
Yes,
I know earlier we talked about the net neutrality and access to that, but I'm just asking a general question. Like, isn't it the ISPs have a responsibility to take ownership or stop some of those usage of unwanted or unsocial things? I know it's a layman's question, but
no. Right. No question can be.
No, the reason is
Yeah.
the ISPs basically allow or maybe kind of transport the data or anything. But why not they take the responsibility to stop or maybe filter it out, so that knowing that this is generally not acceptable across things?
Yeah, extremely good question. Thanks for asking that, Ramesh. In fact, see, that is one of the objectives of this new act, where, right now there is something called safe harbor, where, the intermediaries are not responsible, or they are not penalized, or they are not liable for this. But this proposed act I think, if you go to, the further slides, there is a question mark. That means the government is seriously considering this particular aspect, where they will make for example, if it is Facebook or Twitter, they want to make them accountable, or YouTube, they want to make them accountable for this content. So that is a possibility. But again, to what extent the content can be filtered? Only after somebody watching that content, that can be done. And probably the AI tools, the artificial intelligence tools, also probably they can be developed going forward. But right now, in my opinion, there is a limitation. Even though the government intends to do that, in my opinion, I don't know how effective that can be done. Probably others can add their opinion, probably Navi and others.
No, there is definitely a thought process in the government today that the safe harbor concept should be completely given up also. Okay, this was one of the discussions I had with the ministry people in the interaction we had on 9th of March. Not that a decision has been taken on that, but definitely, as if you can look at the current ITA 2000, the definition of intermediaries, the section 79 protection is available to only such intermediaries who are actually not, interacting with the data. They are not modifying the data. They are not choosing the receiver of the data and so on. But today, there is no intermediary who is not using the data. The moment they start using the data, they lose the safe harbor privilege. Intermediary is one who actually transmits the message from one end to the other end, does not do anything with that. But today, because we want to monetize every data, there is no intermediary who will do a free service of only transferring the message like a router. They all try to look at what is the data, and from that data, they will pick up some information which is good for advertising and other things. So such organizations anyway will not qualify as intermediary even under the current law. So the real intermediary benefit of section 79 is available only to a very few organizations like the ISPs and MSPs. But you remember, even ISPs, I have pointed out some time back about Airtel. There was a view that when Airtel browser is used, that itself actually picks up some information and so on. So even the ISPs and MSPs have actually voluntarily given up their intermediary status. And if that is the trend, it is possible that government may think there is no use of this safe harbor. We want intermediaries to be accountable. Accountability is one of the important things which the minister mentioned again and again. They want intermediaries to be accountable, which means that the safe harbor provision could be diluted to the extent that the industry will have to make arrangements to absorb the responsibility and liabilities. Just as we today have duties for a data principal, should there not be a duty to a intermediary? This is something which I strongly hold is necessary, and I think the government is moving towards that. Yeah.
Sure. Thanks, Navi. So, a few minutes ago, I mentioned the current model where, we have everything in bits and pieces. They are not aligned. They are not comprehensive. And, the proposed new act, it's very good in my opinion, where I can say, there is the National Data Governance Policy and the proposed Digital Personal Data Protection Act also aligning with this Digital India, proposed Digital India Act. Of course, any act will have rules. And the major, what I can see, the big difference I can see is, currently in the current form, what is there, most of these FIRs you see, you will have one, today any offense for that matter is committed, through the computer or the mobile or the electronic devices. And even the digital forensics, for example, even if it is the other blue collar murder, blue collar crimes, I can say, Even their forensics also uses digital forensics today, by locating through a person's mobile phone, where the location and other things. So we cannot go beyond the digital forensics today. So the important major change what I can see is these cyber crimes, whatever we see today, particularly in the section 67 of the IT Act, probably they will be moving to IPC. See, again, I don't see any big difference. I mean, you will have one section of 66F or C or whatever, and then again that comes with the IPC section of 499, 500, or the theft and other things. So moving to IPC, in my opinion, makes great sense. I know there will be disconnect and the disagreements or disapprovals, but in my opinion, moving these cyber crimes under IPC makes a lot of sense. And that will also, the burden on the law enforcement agencies also will come down, in my opinion. Any questions or the thoughts?
Yeah, go ahead.
Okay. So I think most of these things we already discussed. I mean, this is more of a statistics, okay? Where when I mean, it is just giving the statistics. I think one important thing I would like to pick up is the social media. The social media has really, it has disrupted the the online today, where a lot of fake news, hate speech, disinformation. Okay, that is happening, and well, again, not only the present IT Act 2000, even the new proposed Digital India Act 2023 also will not be able to handle this, in my opinion, because see, this is a very different thing altogether. The hate speech and the fake news. Unless there is intention by the state government and the union governments, this hate news cannot be stopped. And the fake news is, again, there has to be some agency where the government agency which will certify whether it's a fake news or not. Today we have seen everybody, the face news generators themselves have become the authority to certify whether it is a fake news or not. So the internet today, or the social media, it has gone to, it has degenerated to such an extent that it is extremely difficult for normal people to believe what is right, what is not right, what is true or what is not true. So that to that extent, it has degenerated, in my opinion.
So Viswanath, just a minute,
Yes.
comment.
Yeah.
Now that given a challenge, like we have this development of AI, let's call that OpenAI, ChatGPT. Some of them kind of really give an authentic, essays or information, which are because they pick up from the internet and the same thing represent.
Right.
It's very difficult also to isolate them or maybe to do it.
Correct.
And again, I know earlier even Navis had discussed this in earlier things. So that's going to be real harm.
True. See, again, right now what we see the Google and the Bing and others, they're all search engines. Yes, tomorrow when something like ChatGPT or GPT-4 or whatever, when they present their views, more or less it will be biased views only. I mean, some will like it and some may not like it. And it's a big challenge going forward. No doubt in that. I completely agree with you. And see, again, most of these things what we see initially, when posing as somebody, luring somebody for money, for other things. Internet, and particularly today's the generation also has adapted to such a level to this new world that it's very difficult to differentiate between right or wrong. Anyway, I do not know how the new act will address all this, because no law can address this. It is a social degeneration, I can say. So I think goals of DIA. We for a few minutes we discussed about this. This open internet, online safety and trust, the accountability and quality of service. Again, the quality of service, I can say it is based on what we pay. We will get for what we pay. And adjudication mechanism. Here, see, this is a big change. What I foresee. See, today, I'm sure more than 99% who are present here will agree. If at all, if I lose money today through, somebody takes say 99,000 rupees from my bank account, to file a complaint, police complaint, it is such a big hassle. As per the law, we should report it to the nearest police station. But if I go to the nearest police station, they will tell us to go to the cybercrime branch. The cybercrime branch will say, okay, since it is less than 1 lakh, you go to the nearest police station. And some will say, just there is one Ministry of Home Affairs website, you log in there. Again, if you log in there, also it will come to the same jurisdictional police station. Ultimately, the person who has lost money, the victim, has, he doesn't know where to go and what to do. So such is I can say the pathetic situation what most of us are today, where the victims do not know what to do, whom to approach, and there is no resolution. If you lose money, it's gone. We are in such a state today. And hopefully this will change. Today there are few cybercrime police stations which I myself have visited many times. That is, in my opinion, that is no different from the ordinary other police stations. They are also it's the same set of people, the same set of officers who will move from normal police station to cybercrime police station during their transfers. One is the lack of the integrity, and other things, the lack of the knowledge or the seriousness in handling cybercrimes. That is also there. So hope the new changes, not only in the law, but on the ground also will change in addressing this. The adjudication mechanism, again, it will go to the normal courts today. A few cases will go to the cyber appellate tribunal. But in my opinion, since it is a specialized subject, it's a techno-legal subject, there has to be a specialized tribunal for this, like the fast-track courts, where any cyber crime for that matter, which is reported, should be handled through that tribunal, and and it has to be fast-tracked. That is my opinion. Probably, if anybody else has other opinions, also that can be shared. And the evolvable digital law. See, again, when my opinion, this particular slide is another just an add-on. See, nobody can predict what happens in the technological field. Tomorrow, we don't know what comes out and who will, from which part of the world somebody will come out with some new technology. Having a law to address the emerging and the future technologies is impossible, almost impossible. Based on today's today's requirement, let there be a new act, let it come into force, and as and when required, there can be amendments made. And this is what the structure which is being proposed. If you see, interestingly, either the number 8 regulatory framework, I assume only this tribunal and other things will be here, and most of these crimes, the cyber crimes, will go to the IPC. So this we discussed about the open internet, the choice, the competition, fair market access, fair trade practices. See, right now, most of the things are handled by the Competition Act in India. And I don't see that changes much. And we mentioned about this, the foreign judgments where there was no net neutrality. Even the fake news also we discussed, and some of this, right to be forgotten, right to redressal. See, right to redressal is part of the Constitution. Right against discrimination is also part of the Constitution. Right to be forgotten, I think it will be included in this Digital Personal Protection Act. One interesting concept has emerged in this. If you see, do not track. Well, I remember, when the mobile phones were newly introduced, we used to get a lot of calls, the marketing calls. Government came up with something, or the TRAI came up with something called do not disturb. I myself, I registered in that. But still, even today, I get the marketing calls. See, do not track, even though the concept looks good, it is difficult to manage this, to protect minors' data, privacy of children on social media. Well, this defamation, cyberbullying, all this, they continue to exist, whether it's the old act or the new act, they continue to exist. The pornography, dark web. So, well, the intention of the government is good. They have listed down the existing problems. To what extent they can really handle this is, it's another question. I mean, all the new spy cameras, wearable tech, all this has come into picture, the AI systems. But to what extent they can really address this is a question. Again, the foreign judgment has said. Disinformation. Disinformation we discussed, a lot of fake news everywhere. And here it's about, when the three service providers or the intermediaries have been listed here, how the content has been removed. But this continues to exist. The accountable internet. And in fact, in the last session, what we had about the AI, I think, Navi and others were discussing about the ethical use of AI-based tools. That has been, if you see the point number 2, it has been listed here. Ethical use of AI-based tools. So, the deep fakes and all, these are all the part of the technology. It is easy to put on the slides, but to what extent they can really handle using the law is a matter of, it's a different thing altogether. We discussed about the safe harbor. There is a serious thought process to remove this, the protection given to this companies, and probably the protection from the penalties and the liability may go. But we saw what happened in many other cases, like including Twitter, or even this bringing this Digital Protection Act, that's Personal Data Protection Act as well. There is a lot of lobbying going on, and the foreign companies, they're arm twisting the government and all. So to what extent the government will succeed in removing the safe harbor, we need to see. So this is the standard again, this is the first time, as I said, before the draft of the bill itself is in the public domain. There are consultations on this, which is good. It is a positive development in my opinion. And after probably 2 or 3 such interactions, the draft bill will come. Again, once the draft bill is in public forum, it will be opened up for consultations, public consultation, and anybody can give their comments. And then the draft, it will go to the cabinet for approval, and then it will go to the parliament. See, at least what I see is probably this year may happen, by June or July, something the draft bill may come out, and all the public consultation probably it goes up to December, in my opinion. So this is how the proposed Digital India Act is proposed in India to replace the existing IT Act of 2000 with the new set of challenges what the society is facing. Open for questions. Any questions will take.
Yes, hi, I had a question. So, is there any timeline indicated, or we could expect a bill in any form to be sort of laid out for public comments or discussion?
Yeah, probably, anywhere between July to September, it should happen.
So during the interaction, the government said that they have named this as DIA 2023 with a specific thought process that they want this act to come as quickly as possible. Minister has told that they will be perhaps having a window of 4 to 5 months before the draft will be finalized. They have given the email address to which the recommendations or suggestions, if any, can be sent even now. As you have seen, this particular presentation is more or less a kind of an umbrella view of what the Act proposes to do. But even on this, if somebody has got some kind of suggestions, it can be sent to them. And as soon as possible, they will release one version of the draft, based on which further discussions will happen. So what I personally got out of this meeting was that government is very serious in getting this bill through, not like the DP data protection bill, which went for 5 years, but they want this to come as quickly as possible. One of the major changes which could be done and which can also cause some hiccup is the transfer of all the cyber crimes to the IPC. In fact, the entire chapter 11 of ITA 2000 may go into IPC, and this particular law, in a way, it will only talk about penalties, civil penalties, supported by a proper adjudication system. In fact, if you see the latest DPDPB, there also the same principle has been used. The one section on which criminal offense was there, which was that re-identification of de-identified information, which was there in the earlier JPC version of DPA, has been dropped in the DPDPB. So the Ministry of Information Technology is very clear that they want to keep themselves away from the criminal offenses. So that is one major change which can happen. And to compensate for that, they will be adding a lot of industry related promotional things in this particular law, like how to promote the use of AI, maybe blockchain, maybe metaverse kind of a thing. So it will not be a restrictive legislation. That is why they say this will be principle based, and they are talking of 1 trillion digital economy. Basically, if you remember, ITA 2000, one of the objectives was to promote e-commerce. Secondary objectives actually came in the form of cyber crimes. In fact, the first version of ITA 2000 had only 4 sections of cyber crimes. Only in the 2008 version, it actually expanded into a cyber crime law of a big nature. Now, this law, they are trying to go back and say that we will have regulation of IT industries. We will have a civil penalty section, and they will actually enhance the penalties. In fact, if you have seen, even in the Jan Viswanath bill, which has proposed a few changes, it has already taken this concept in terms of amendments to Information Technology Act. They are going to increase the penalties from 1 lakh or something which is there to 10 lakhs or 20 lakhs. That is one kind of change which they are going to do. And they will be decriminalizing some of the sections in which there was a 1-year punishment, 2-year punishment, particularly for the administrative things. Like in the case of a certifying authority, in that this thing, there was something certain had some criminal powers. Those things will perhaps be they are being removed in the Jan Vishwas bill itself. Now, in this particular bill, they will be perhaps bringing in the responsibility of the Ministry of Home Affairs to take over the cyber crime affairs, and this will become purely an industry promotion bill, along with because there will be principle-based prescriptions. That not following that principle is like non-compliance. That will be supported by these penalties and some kind of adjudication system. They may link up this adjudication with the grievance redressal mechanism they are setting up, and probably the cyber appellate tribunal will go. So this adjudication will be there, and then it will go to this grievance tribunal, and then it will perhaps go to the High Court. That is the mechanism which they have used in DPDPB, and the same thing they may use here. So the entire structure of governance of you can say cyber crimes will undergo a change, and that way the face of Information Technology Act will undergo a big change, and it become a more of an industry promotion kind of a legislation. It may be good, in fact, in terms of overall perception, but definitely police will have to do a bit more of internal training to understand cyber crimes and have a proper management of cyber crimes.
Yeah, thanks, Davi. So there is one question by Dr. Shankara Gomati.
Yeah.
How can cyber attacks be prevented in cloud computing? Okay, just to answer this, just not only in cloud computing, but nowhere this cyber attacks can be prevented 100%. Okay, so I mean the very idea of this itself, there is no safe system in the world. However, it can be the cyber attacks can be greatly reduced by taking so many measures. However, if I say that I have a 100% safe system today, that 100% safe system today cannot be 100% safe tomorrow. That's my opinion.
See, these cloud services are actually intermediaries. We know that. Even today, by the definition of intermediaries in ITI 2000, cloud services come under the intermediaries. Now that is going to be reiterated in this DIA, because they are going to have a complete chapter on intermediaries. So presently, the intermediary definition was linked to one particular definition section and then section 79. But I think in this particular bill, they will devote an entire chapter on different kinds of intermediaries, and perhaps propose some fine-tuning of regulations to specific intermediaries. And I'm sure that this time maybe cloud service providers will be perhaps specifically mentioned. So all platform people and other things. In fact, platforms are the real intermediaries. I create a platform and let some user use that platform. Then the platform remains an intermediary. The user is a consumer of data, and he takes the responsibility as a data consumer, not as an intermediary. He will not get section 79 benefit. Now, this concept has not been properly understood by the industry so far. I hope this DIA will specifically mention who is an intermediary who will get section 79 benefit, that safe harbor benefit, and who are the users of the platform and users on the intermediary who will not get section 79 benefit, and they should not be confused with the intermediaries. And I think that scope will be possible because a separate chapter is being devoted for this particular definition of intermediaries, because you have seen that intermediaries, OTT platform, then ad tech companies, and all these things, and gaming. Gaming already, you know that there is a particular draft notification which is there, but it has not yet become operative. Now, that will be perhaps there will be a specific regulation, because gaming is such a big thing that gaming is related to monetization, related to cryptocurrency, related to addiction issues, and government has come up with what is called esports and online gaming regulation. So they perhaps this particular act will bring more clarity to gaming. And search engines also need to be perhaps addressed a little better, because search engines have been given a lot of leverage so far, because search engines were the, you can say, basic reasons for internet growth. So even in the data protection law, search engines are basically exempted from various things. Now, perhaps there will be some definitions of to what extent search engines will get the benefit, like in the case of this right to forget kind of a thing, search engines will be directly involved. So I think there will be much more clarity in the data governance. And remember, they have also made a mention of non-personal data governance. That is, the government has got something called a data governance policy. They have linked it to this. If you look at the first few slides in which the minister has told about the future, you can say the how the framework of global standard cyber laws would be there. They have made a mention of national data governance policy. That is basically something which is having this Chris Gopalakrishna committee report in the background, where the data from the government and anonymized data from the private sector, all these things will be made available in a particular data lake, and that will be used for the benefit of the society, is the concept. So they are likely to have perhaps a separate policy, and how they will link that policy to this act, we have to see. But there is possibility that non-personal data governance, at least some aspects of that, apart from security, would be part of this particular act. So we are in for a very exciting period, which also means there will be a lot of complications. There will be disagreements. There will be a lot of objections, and but I think these things are good for the development of this particular law. But definitely, this will not be a restrictive legislation. It will be a legislation for promoting the industry, because at the back of the government's mind, this 1 trillion digital economy is there. So if that comes from gaming, it comes from metaverse, they would like to support it, as long as it does not cause harm to the society. So everywhere, if the industry is honest, they can bring in innovation, but they will be held accountable, and they have to ensure that harm is not caused to the society. So it is a win-win situation, unless, of course, the industry becomes something like a challenge to the government. I hope industry will not take that attitude that we will do whatever we want. Innovation is what we want. If they work closely with the government, I think we are in for some good period.
Yeah, thank you very much, sir. But actually, to my viewpoint, we are in a 4G in industry 4.0. In this itself, we are facing so many cyber issues, problems, including banks and other sectors, important sectors, so many other sectors, as you are aware of that. But we are marching fast towards 5G. In 5G also, because of the electromagnetic high frequency interference and causes, will it not affect the human? Because we always have to depend on win-win policy. So including all our application oriented thing and layman operations with the help of a banking sector and so many e-commerce and what else in trade sector also, everything is affecting, because the crime, nobody is, even the educated people cannot able to understand how come the uneducated people. That is what my thinking according to the future perspective of younger one as well as elder one.
See, we cannot do away with the society's status as, you can say, less educated. But remember that at one point of time, we were calling India the developing country or underdeveloped country. But today we are actually in the advanced developed country status. Same way, the population, maybe language and other difficulties will be there. But in terms of usage of digital media today, India is at the forefront of the world. So you can say your vegetable vendor is able to use a UPI, which I think even for somebody in USA will be a great surprise. So there will be, some kind of difficulty arising basically out of cyber criminals exploiting the, you can say, trust-based system which India has always been. We trust the next person. The moment you shake hands with me, I don't look at you as a criminal. I start at looking at you as a friend. That is the culture of India. Whereas if you look at the Westerners, you try to talk to them, they will start with this kind of a suspicious kind of a demeanor. So I think that is the basic difference. Then cyber criminals could exploit that. That is where the accountability of intermediaries becomes important. Intermediaries should not side with the cyber criminals. They should actually side with the public and try to protect the public's interest. Otherwise, the accountability has to rest with the intermediaries. This is the right approach. And even the current ITA 2000 had these elements, but nobody gave a lot of importance to that. If that is done, see, that is the reason why we are saying banks should be held responsible for phishing, or Twitter should be held responsible for fake messages. The reason is that we want the intermediaries who have the capability of regulating or making some controls actually try to help the law enforcement. Otherwise, the trust in the whole system will actually be eroded. In fact, today I was seeing somewhere that pornography has killed the development of internet and various other things, and even the AI also. It will come and kill AI now, because already the chat GPT is being used by criminals for spamming and other things. So that way it will happen. So that is why accountability of intermediaries is very, very important. And I hope government will give as much importance as possible to that. But this law will only talk about fines, maybe 1 crore, maybe higher or something like that. But the criminal aspects of intermediary liability will shift to the IPC.
Thank you very much, sir.
Okay, any other questions? Bondaya, you must be having some thoughts. Subraidu.
Satish,
yeah, please. Yeah. Any of the new people who have joined today, if you have any questions, please let us know. We are all actually, see, this is a nascent stage of the new act. Neither PB nor me know anything more than what is there in this particular set of slides. I can say because I attended the meeting and had some chat, I had some additional this thing that is different. But beyond that, we are at the very beginning of a new legislation. In 1998, the same situation was there in Information Technology Act. So now we are in the same situation. So we are all trying to understand the intentions of the government and perhaps, if possible, influence them towards a positive way of looking at things. Yeah, Satish, you have.
Sir, thanks for inviting us to this one. And it was a great presentation. Sir, my question is, apart from IPC, is there any other acts which is in scope for change? As you know, in as part of 2000 IT Act 2000, I think 6 acts were modified. Evidence Act, I think the Evidence Act has to undergo quite an amount of change to and take care of the digital evidences, especially a lot of it is still I when I speak to the Sen police station people, they mention the Evidence Act or collecting the evidence as the most difficult part in their trial, and that's why they're not able to close many of the situations. So I think we need to kind of have one. And is there anything that is in scope for change?
Right now, no mention has been there. It will be there in Indian Evidence Act itself. And since crimes are also going to be shifted, the IPC managers will take care of that. But just let me tell you one thing. The Indian, whatever amendments were made in the Indian Evidence Act, in 2000 and some one or two things in 2008, they have been very, very innovative. See, they have defined electronic documents as evidence, so there is no basic doubt about that. They have introduced a system whereby you don't have to seize hard disks and bring it to the court. You have to seize the electronic impressions and bring it to the court. Say people are not able to understand this. Many times we say CD is an electronic document. CD is not the electronic document. The binary information which is lying inside is the electronic document, and that is the evidence. Indian Evidence Act Section 65B recognizes this and says that you need to actually bring in the electronic evidence in the form of a certified variety and then convince the court. So that, in fact, if you see the Data Protection Bill, DPDPB, they have specifically mentioned that the inquiry officers will not seize the instruments, that is the computer devices. They will not stop the activities of the computers, because in the early stages of ITA 2000, I remember that police have gone and locked up the server room because there was some complaint. Okay, there is a complaint, and the evidence lies somewhere in one of those servers, and police cannot understand what is the server, where is it. Okay, so actually in Madras, they actually closed one server room for a few days. So those things, now the DPDPB says that there is no power for the inquiry officers to do that. So similarly, here also it is possible, and that is what is made possible because of Section 65B. That is, you can sit in the place where the evidence is supposed to be there. I can connect my computer, record whatever evidence I want to take, get a certified copy of that, and walk away from that, so that the company is not going to be under any difficulty. So these kind of useful provisions are there. Now, only thing is, it has taken 20 years for people to understand this. And probably some clarifications may be there, but there is perhaps enough in the earlier amendments to take things forward, both in the Indian Evidence Act as well as some things related to digital signature and other things. There are doubts, there are difficulties in understanding. Some clarity may help, but otherwise there is enough legal provisions to support the changes which may be necessary to be made. Last time they made a change in Criminal Procedure Code, they made a change in Bankers Book of Evidence Act, IPC, Indian Evidence Act, and I think most of that will stay. Now IPC, they are anyway going to make a total change, and CRPC will also perhaps get some kind of a change. Otherwise, as of now, also Indian Evidence Act, other things were not interfering with the other aspects of the governance, like digital signature and other things. So I don't know whether too many changes are required in other acts except IPC and connected with that CRPC.
Sir, is there any mention about the police reforms? Because I think that is a
In fact, I did ask this question to Mr. Rajiv Chandrasekhar directly, because I have been telling that we need a separate police cadre for cyber crimes, because what is happening today is police is not able to absorb expertise, and technology is changing, and it is perhaps there is difficult for the police to keep track of it. But his view was that they would not like to bring in the policing to the Ministry of Information Technology, full stop. So if anything has to be done, it has to be done by the Ministry of Home Affairs. So police reforms also is the responsibility of the Home Affairs, and Rajiv Chandrasekhar has washed his hands off the cyber crime area. Along with that, any police reforms, don't ask the ministry. You can ask the, not the IT ministry, you can ask the Home Ministry. This was a direct response I got from him.
That will defeat the whole purpose or the effectiveness
Yes,
of this.
that's what I told, because effectiveness of the law is in implementation. The adjudication also in the last 20 years have not been as good as it would have been done. You know that I myself worked on Uma Shankar's case for 14 years. What should have happened in perhaps 1 year actually. The original, this thing is 6 months in adjudication, 6 months in appellate tribunal. It should be over in 1 year. In Uma Shankar's case, it took about 12 years for these two phases, and then it went to the High Court for 1.5 2 years. And there have been instances of adjudicators not accepting cases, sometimes giving a completely wrong views. So they have not lived up to the expectations. So adjudication has failed. In fact, this is what even Mr. Prashant Mali was telling in the meeting. We know people who have worked in adjudication, no adjudication has failed. Okay, we may not say it openly, but it is so. And cyber crimes, police also have not been very great. Okay, 1 or 2 things they have done, but not great. So this enforcement will continue to be a challenge. And I think that is beyond the lawmaking. We have to make the law and then see how it can be done. This will remain as a thing which we have to handle.
Thank you, sir.
Okay. If no other question is there, Manju can take over.
Okay, sir. Thank you, Mr. Viswanath, for a wonderful session, introducing and interpreting the Act for the benefit of all. Thank you, Navi sir, for adding your valuable inputs and comments. Thank you everyone for making the discussion lively. As you know, this Act is in draft stage and more changes and inclusions are expected. This is an exciting phase and we'll have more sessions to discuss this as and when we have new views on this. Thank you everyone for joining. Good night.
Thanks everybody for joining. Thank you.